Thanks, Craig, and welcome, ladies and gentlemen, to the seminar today. The farm debt mediation process has been in various forms in Queensland since in the mid-1990s, and the information provided today is general in nature, and you will see that I'm not very good at doing these slides, but the video is being prepared for community legal purposes only, and there's the usual disclaimer that would be applying to any of these types of activities. Today, just do a general overview, and for those of you who are quite familiar with the process, it may be just capturing some of the, well, all the information that you'd be quite familiar with. However, people that aren't familiar with it, the Queensland Farm Finance Strategy is the process which provides the guidelines and philosophies behind negotiations and mediations in Queensland. Now, it's been since about the mid-1990s, around about the same time that New South Wales created Farm Debt Mediation Act, and that was in 1994. The strategy came into place, it was negotiated around that time, it came into place I think about 1996. The strategy doesn't just necessarily deal with mediation, and I'd like to emphasise that it relates to all the negotiations that you may have, that farmers may have with banks. However, given that mediation is one of the outcomes of the process, I thought it's necessary to go through what mediation is. Now, mediation actually came into being as it's regarded as alternate dispute resolution, and it was developed around about the same time, or in the late 80s, early 90s. It became very popular, probably a lot earlier than that with other jurisdictions, family law and other types of dispute resolution processes, but it was introduced as a result of people wanting to be more control of the decision-making processes instead of having a court make a decision for them and imposing a solution on parties or tribunals or those types of jurisdictions, that the people themselves come to a resolution of matters without having a decision imposed upon them, that they are part of the process. So a couple of the cornerstones of the mediation process is that it's confidential meetings between parties, and the confidentiality is very, very strict, and it enables parties to that particular meeting to come to a solution that no one else need know about. The meeting is chaired by an independent person, as we've seen in the slide. It's the mediator. Now, part of the confidentiality relates to the mediator as well, and I'll touch on those issues in the next slide. The other legal concept involved with the mediation process is that the discussions that are held are on a without prejudice basis. That's also a legal term that's used for most legal negotiations that are conducted in that fashion, and it's for the purposes of negotiation, so as parties can speak more freely and openly about what is concerning them without fear of those matters being raised in court. And it also allows parties to introduce evidence or material that may not be evidence if it went to court. The mediation process is where people will sit around, basically just a meeting where Each party is given equal opportunity to raise concerns about the issues that confront them, and each party is given equal opportunity to respond to those concerns. Each party is given a position that they can provide options to settle the matter. And the other important aspect of mediation is that it's a listening process, not just a speaking process. And from a farmer's point of view, there's significant power imbalance in dealing with a bank. A bank's got its teams of lawyers, has also heaps of financial backings behind it, and also would have, they've got there's huge documents there in their favour, the mortgage documents, the contract documents, and all of those documents that the client had signed years ago when the relationship was created. I'm sure that when the farmer was signing those documents, they didn't have an opportunity to say, look, I don't like that clause in the agreement, in this contract, I'd like it varied. The bank has prepared these documents over years, and quite often they're couched in a way in which is very favourable to the bank and not so much to the producer. That's the reality of the situation. And so when people come along and have meetings with the bank, it's often they're sitting there being told what the bank's going to do, or they've also have letters of offer which imposes certain obligations on the farmer. So the mediation process does park a lot of those powers at the beginning of the mediation, enabling parties to sit there, and as I said, it's the only time that that the bank must sit there and listen to the client's concerns. Now, that's in reality, in practice, often banks are far more amenable to sitting and trying to negotiate outcomes, even outside of the mediation process. And we'll also touch on that in relation to the Queensland Farm Finance Strategy, which talks about both parties being obligated to conduct themselves in a manner which provides for open and honest discussions, treating each other with dignity, etc. However, just with the mediation itself, strictly speaking, it's an opportunity for both parties to sit and listen to what the other party's position is. Each party is encouraged to look for options which might achieve agreements. Now, the mediation process, whether it's farm debt mediation or any other mediations, these are the sorts of guidelines and principles which operate. It's often said that a successful mediation is one where both parties actually don't feel tremendous about the outcome because that required both of them to compromise. It's compromise from a position that they might have had, but it's a compromise on the basis that they're prepared to live with the outcomes from both points of view. So it enables both parties to sit there together and try and come to a solution that both of them can agree upon. Now, the mediator role is to sit there as an unbiased, impartial third party. Often people, when we've had mediations that people who have been in a mediation before, sometimes they confuse the role of a mediator with that of an adjudicator or someone not so much in the function of a judge, but sitting there in judgment of them. And the role of a mediator is not to act as judge or jury. Will assist the parties to explore options to resolve disputes. Certainly won't provide any legal advice to either party, and will act impartially and fairly towards each party at all times. Each mediator will have a different approach. Some will say, look, this is an option, how about you consider this option? Others will have a different approach, but there's an ability to provide options, to sit there and to try and ensure that the parties that are at the meeting are using the time usefully, exploring options, discussing issues. The mediator will be responsible for the conduct of the mediation, and prior to the mediation they'll send out to the participants the rules of engagement. Generally the normal rules of engagement are that people will be courteous to one another, won't disrupt the proceedings, won't interrupt the other when they're speaking, and just setting out just normal housekeeping rules. The mediator does have the power to stop the mediation at any time if he or she believes that it's not achieving outcomes, or if there are reasons that they believe that the mediation should cease. So they do have a power in that respect, and they will normally ensure that the process runs sensibly. There are times during the process where the mediator, often at mediation they have all the parties sitting around the table, but at times the mediator will see that it's best that the parties be separated, and that at any time the mediator is speaking to one party in the absence of the other, those conversations are completely confidential and can't be disclosed to the other party. Likewise, prior to the mediation, so before the mediation, they can have discussions with parties that are going to be participating in the mediation, just to gather information, etc. Sometimes when the mediator is having private discussions with the parties during the mediation process, they can be more candid, just in some respects reality testing their position, or you know, trying to work out how to deal with what the other party's position might be. The mediator cannot be forced to give evidence about what occurred at mediation. So if we go back to that concept of confidentiality, what happens at the mediation, that if there are, unless there's issues of a criminal nature or something like that that happens at the mediation, nothing can be disclosed outside of that process. And if we just say on a general basis, let's say no mediator can be forced to give evidence about what occurred at mediation. Certainly, as a lawyer, the mediator can't act for either party against the other. And in farm debt mediation matters, we find that because these relate to contractual obligations that the parties have, they also relate to rural matters. We believe and we always ensure that the mediator is appropriately qualified mediator, who's done the training, has a lawyer with commercial background and background with dealing with financial matters, and also having a rural background and understanding the issues that might affect particular rural people. That we feel that's quite important, that understanding is there. Now at mediation, the farmer is not obliged to reach an agreement at mediation. There is no obligation on the parties to have an agreement reached. That being said, a lot of people feel that they are under an obligation to reach an agreement, but that is because the commercial realities are that if they don't reach an agreement, the bank may then be in a position to take enforcement action or other action, which I'll explain what that is in later slides. But that's the reality of the situation Sometimes it's best not to have an agreement. If the parties can't reach an agreement, well, certainly there'll be no pressure provided by either the representatives or the mediator to have an agreement. I can't stress this strongly enough, that any agreement reached at mediation is an agreement that both parties to the agreement are happy to sign off on. And quite often it requires both parties to compromise in some fashion. An agreement reached at mediation is normally able to be enforced by either party. So in the rare occasion that the bank doesn't comply with it, then the farmer has an opportunity to go to the court and have that agreement enforced. Likewise, if the farmer can't comply with the obligation, with the agreement, then and it's necessary to enforce the agreement, then the bank could go to court to have that enforced. You often hear the legal concept of good faith. It's not specifically defined, but there are various ways of defining good faith, but everyone coming on to mediation has to come along and act in good faith towards one another. And that doesn't mean to say that being in good faith that you must reach agreement. But you'll find in the Queensland Farm Finance Strategy and in various other jurisdictions that good faith is referred to on a regular basis. But as you see on the slide, extending normal courtesies, having an open mind and listening to the other party, and giving consideration to the counter proposals from the other side. It won't be a breach of good faith by putting forward an unreasonable position, but that's in an extreme situation. Now, the mediator does have a power here. If they determine that parties have not acted in good faith, then in the Queensland Farm Finance Strategy, the mediator, at the conclusion of the mediation, if the mediation has been conducted in good faith, the mediator will sign a certificate. But if it hasn't been in good faith, that the mediator's determination alone is that one of the parties hasn't acted in good faith, and we can say here, if a bank is found not to have acted in good faith, the mediator will not issue a certificate satisfying the criteria that a mediation took place, and the bank will not be able to commence enforcement action without the certificate. In Greg's introduction, he talked about many hundreds of mediations conducted prior to commencing with legal aid. Well, I've actually many hundreds of mediations from the time that I became a mediator to now, but in all the mediations that I've been involved in under the Farm Debt Mediation arrangements, there's only been one occasion when that issue was raised in relation to bank behaviour, and that, on two occasions, and one was that the bank had issued court proceedings prior to the mediation, and the mediator said to the bank, "You're not acting in good faith, you must withdraw those proceedings before this mediation proceeds." And in another instance, there was concerns about the behaviour of a particular bank officer, but that it did actually end up resolving itself. Likewise, if a farmer doesn't act in good faith at the mediation, then the mediator will issue a certificate to the bank enabling it to commence enforcement action. Now, I might just say that the Queensland Farm Finance Strategy, and I'll cover all this in later on, that it does say that it's not law, but each party's position prior to legal position at the time of mediation is parked outside, and when you come into the mediation, each party is has the same legal position that existed prior to the mediation is parked. Now, under the Queensland Farm Finance strategy, banks aren't to take enforcement action until they've been through the mediation process. However, the true legal position is that given that it's not an act of Parliament, the banks do have a right to enforce action, and that is the legal position. That's the reality of the situation. So failure to reach agreement at mediation, if agreement is not reached, then each party is returned to the same legal position as before the mediation. And the mediator will issue a certificate confirming a satisfactory mediation took place. If a satisfactory mediation has taken place, then the bank will have fulfilled its obligations under the Queensland Farm Finance strategy and will be entitled to take enforcement action if no agreement is reached. Now, enforcement action is defined under the Queensland Farm Finance strategy as, now these are the actions that the bank can't do until it's been through the mediation process. But, and it's also subject to what agreement is reached at mediation. Generally speaking, parties are able to reach an agreement at mediation, and the rights to enforcement action are postponed during the period of the agreement. But, so as you're aware what the enforcement action the banks can take, and this is under normal circumstances outside of the mediation process, is that they can issue a notice of exercise of power of sale, they can advertise notice of sale, take possession or commence court proceedings for possession of the farm, commence court proceedings for recovery of the farm debt, issue warrants, appoint receivers and the like. Now, all of these steps are contained in the bank documents when you are outlined in the bank documents when mortgages are entered into, but they're the steps that the bank can take. If however a property is abandoned or the property is at risk, the bank doesn't have to offer a mediation process and can take steps to protect the security the bank has. Now, there are some facts and fictions about the Queensland Farm Finance strategy, and some of those are here. It's more about the mediation process in a lot of ways. Facts are that the mortgagees, whether they're banks or other financiers or any other person who has provided money and taken a mortgage over property, has powers to exercise rights and enforce their securities in the event of default. I'm sure you'll all be aware of that. The mortgagees who have adopted the Queensland Farm Finance strategy have postponed those enforcement rights and will offer mediation. And here's another fact, that farmers do not forego their rights to go to court by agreeing to go to mediation. Often mediating parties reach agreement at mediation and both parties can rely upon that agreement. Now, if we go back, that farmers do not forego their rights to go to court by agreeing to mediate. Some of the myths are that the banks must agree with the farmers' proposal at mediation. Banks must agree to offer debt write-off. That's often a question that's asked in preparation of mediation. How much is the bank going to write off? The reality is that there's no obligation on the bank to write off debt. And some people feel that the banks must agree to the timelines proposed by the farmers to either sell, refinance or other. That's another myth. These are matters that are all negotiated during the mediation and will depend on various circumstances at the time. Another thing is that the farmers must accept the bank's proposals, and that's once again, a myth that it's a negotiated outcome, and for farmers forego rights to take court action if they've undertaken mediation, and parties are forced to reach agreement at mediation. Now, the Queensland Farm Finance Strategy, for those of you who aren't familiar with it, can view it on the Queensland Farmers Federation's website, and there's a link to it. Some of the things to note about the strategy: it's not law. It's an industry standard. So, in other words, it hasn't been approved by Parliament. It's also a voluntary process. Farmers cannot force banks to mediate or to negotiate under the provisions of the Queensland Farm Finance Strategy. However, if a bank is offered mediation, farmers can confidently assume that it will comply with the strategy. It's limited to banks who are members of the Australian Bankers Association. Now, there is a footnote there that the ABA is unable to force its members to participate. However, I'm fairly confident to say that all members now, ABA members, do offer mediation. So quite not often, but sometimes we do come across other financiers, smaller banks, other lenders who are not part of the Queensland Farm Finance Strategy and do not have to offer mediation. So this is the current situation in Queensland. Under the Queensland Farm Finance Strategy, one they're entitled to have access, this is straight out of the strategy itself, entitled to have access to professional advice as part of the lending process, be informed in writing by the bank of any financial problems, be informed of any significant change in bank's assessment, be encouraged by bank to take remedial action to resolve issues, and it also says that the banks should negotiate in good faith, confirm in writing to decline financial support, offer farm debt mediation before taking enforcement action. And as said, you'll find that the banks are all now complying with certainly the mediation part of it, and are also embracing the concept, I suppose, as much as they can. Both banks and farmers are obliged to, this is contained in the strategy itself, so it's an obligation by both parties. Communicate openly and honestly, share information and documentation where appropriate, and that is a bit of an issue which we advisors have with the banks, so we don't believe that information, the necessary information, has been adequately provided, and it's an ongoing issue that we have on a regular basis. Treating each other with dignity, respect and courtesy, and I can say that the vast majority of people that have any experience in this area from the banks recognise that that's a necessary part of the process, and it's only when someone new to the process comes in and may have not been familiar with those concepts that it has caused some issues. However, you can rest assured that now, with education, with the various bank officers who participate in this process, are now coming along with a better understanding of how to conduct themselves, and both parties must act in good faith. So you can see that's another, that good faith pops up on a regular basis. There are other avenues available to farmers apart from mediation. There is a Financial Ombudsman Service. Now that service is actually, I believe it's owned by the Australian Bankers Association, or funded by the Australian Bankers Association, and there's various, there's other Credit Ombudsman Service, Financial Ombudsman Services, etc. They offer, you can go to those Ombudsman Services and ask them to investigate matters in relation to the conduct of the financial providers. They are limited in the value of the debt, that it's got to be $2 million or under, and the level of compensation that can be awarded is up to $500,000. There are, you'll see further on, you'll see that there have been some inquiries, recommendations that that these jurisdictions be expanded. As I said, the Financial Ombudsman Services, the Credit Ombudsman Service, and a few of those. There is an issue in relation to farm debt mediation and the Financial Ombudsman Service, that if the farm debt mediation has been offered and accepted, that at the moment the Financial Ombudsman Service has said, no, we won't look at those matters, and secondly, that if a matter's been through mediation, that they won't investigate it further. However, there are some reviews in process at the moment, and the protocols may alter. Now, farmers' rights outside of the mediation process, not only including Financial Ombudsman Service, but they can go to court at any time, and the caption there, it says, unless otherwise agreed to with the bank, that often at mediation, both parties agree, look, this is our final agreement, we don't want to have any other court proceedings, etc., and the concessions made are on the basis that the farmer forgoes any right to go to court. Now, you'll find that most banks will ask for that, not most banks, some banks will ask for that to be included in the agreement. Generally, if the bank's represented by lawyers, they'll ask for those sorts of inclusions to be put in the agreements that are reached. Farmers have to consider that seriously. If there are issues that the farmer was aware of prior to mediation that may possibly have needed the intervention of court proceedings, those issues would be flushed out and discussed as much as possible prior to that. So, and have an idea of what the costs would be, timeframes and whatever of the court process. But there's nothing to say that you can't go to court, the farmers can go to court to enforce the agreement reached at mediation if the bank doesn't comply with that agreement. Now, what can lenders do? If they're a signatory to the Queensland Farm Finance Strategy, and most of the lenders that farmers do obtain loans through, all the majors and etc., this would comply. They'd be complying to this. They can ask a farmer to comply with their terms of letters of offer. That's the letter that you would receive when the finance is being provided or when on a review. They can issue letters of demand if there's been a breach of those terms. They can ask a farmer to enter into negotiations, and under the Farm Finance Strategy, the banks and farmers are encouraged to enter into negotiations at an early stage to try and address problems before they become major issues. If they have entered into negotiations and that agreement has broken down, or that the bank is considering enforcement action, the bank must offer farm debt mediation. It can proceed to enforcement action if the farmer does not accept the mediation. Now, some farmers feel that they must go to mediation for that, and look, that is somewhat a legal reality, but that's where it is. The bank can enforce its security if mediation terms are not met. So if the farmer is unable to comply with the mediation agreement, then the bank will reserve its rights to take enforcement action at the expiration of that time. Now, you can see from if a lender isn't a signatory to the strategy, they don't have to go through all those processes. All they have to do is issue letters of demand, then they can proceed to enforcement action, and then they can enforce its security. So you can see there's significant advantages to having the Queensland Farm Finance Strategy in place. Timeframes. Under the strategy, farmer has 21 days to accept the mediation from the date of receipt of the offer, not from the date that the bank has on the letterhead. It's the date that the farmer receives the document. And we often have this as an issue that people inexperienced from the banks will try and rely upon the date of the letter of the offer. Now, the mediation must take place within 3 months of the notice being given or 2 months from the appointment of the mediator. Look, having the mediation when it's taken place will often be negotiated between the parties, because it may be that the parties agree that give the person an opportunity to try and refinance or something prior to mediation. But this is what's contained under the strategy. If a farmer doesn't accept mediation, the bank must wait 28 days from giving the notice before commencing enforcement action. This is just generally speaking. The Property Law Act is the act that sets out the obligations and the timeframes for a mortgagee exercising the power of sale, and it's 30 days from service of notice before they can take further steps. And now, the Code of Banking Practice, it's something that has been developed over the years. This is a code that the banks have agreed to comply with, and it's been developed by the Australian Bankers Association. There's also codes for credit unions and the like as well, but we're just concentrating on the Code of Banking Practice because most farm debt mediation would relate to the majors. You can view that on the website, Australian Bankers Association's website. It's like all legal documents. If you're suffering from insomnia, start reading it, probably put you to sleep. But the courts have found that the banks are contractually bound to comply with the code. So if the bank breaches the term of the code, then it's a breach of contract with its customer. And so the courts are actually enforcing these codes as well, these principles. And the Financial Ombudsman Service will also investigate, looking at, is guided by a lot of these issues and breaches within the code. There's things such as privacy, provisions of credit, when guarantees are being given. There are sections within the code which cover those sorts of activities. One of the things that we often, as advisors in farm debt mediations, look at is often ask, how did the farmer ever get that particular loan? And one of the provisions of the code says that when a bank is offering credit, that it must act prudently when assessing the credit application, and also assess whether the customer has capacity to repay the loan before it offers credit or additional credit. So, you know, they've got to act prudently, and sometimes we really question whether that has happened. As I said, other times people are very concerned about their privacy, and sometimes there is concerns about those sorts of breaches and how the guarantees. Often in farm debt mediations, you might have the parents having provided guarantees for children or other members of the family or farm, etc. So sometimes we'll go and have a look at that. We often will consider the code as part of the process. Now, interestingly, both Queensland Farm Finance Strategy and the Code requires the banks to act fairly and reasonably towards their customers. And I dare say that good faith would also be something that would be interpreted in that fashion. From the lawyer's point of view, there are a lot of other legislations and matters that need to be considered in the farm debt mediation areas. Look, there's Commonwealth laws say that corporations must not engage in misleading or deceptive conduct. Property Law Act, as I previously mentioned, sets out the legislative obligations for mortgagees when enforcing their rights under the sale of land. Credit Real Finance Act applies to the sale of some machinery, not all machinery, but some machinery. And there are also common law obligations for banks and customers. There has been calls for national farm debt mediation scheme to be adopted, and there has been a number of meetings taking place in Canberra relating to the possibility of having a national code or national scheme. In our situation, in my experience, I've had a number of mediations where the farmer might own land both on the Queensland and New South Wales border, and New South Wales has an act, Queensland doesn't. Queensland's is a voluntary process. So dealing with the same bank, dealing with the same loans, etc., the mediations have been conducted under the New South Wales legislation. So you can see there's a lot of cross-border issues. You can imagine in around ACT and New South Wales, Victoria, South Australia, etc. So at the moment there's a bit of a hodgepodge of processes, and in other areas there's no process. New South Wales was at the forefront of providing legislation back in 1994. Victoria took on legislation a couple of years ago, and Western Australia, I have Googled and said that there's a farm debt mediation scheme over there, but Melissa, my paralegal, pointed out to me this morning that it actually hasn't been implemented. It's still in the review process. And part of the review process, it actually says that these mediations over there can be for purposes of resolving a dispute which doesn't necessarily relate to enforcement action, whereas the majority of other mediation jurisdictions talk about having to offer mediation prior to taking enforcement action. So there's sort of hybrid schemes everywhere. It also interestingly says in the West Australian commentary that it's not meant to interfere with the rights to go to the Financial Ombudsman Service. South Australia, I believe, I don't think an act has been passed there, but there is a bill that I noticed on the website. Couldn't find any proceedings in or any act of Parliament in Tasmania. And in Queensland, we have the Queensland Farm Finance Strategy, which we've already talked extensively about. It is still the current process. There has been a bill before Parliament, and there is, I just need to point out and make this absolutely clear to everyone that the Queensland Parliament has not yet passed the Farm Business Debt Mediation Bill. That there's been widespread consultation regarding this process following the Drought Debt Task Force. Interested people can go on to the parliamentary website. There's an extensive reviews and recommendations made there, and it's still a watch and see to see what happens with whether it's passed or not, and if so, what is adopted. And no doubt if it is, we might need to do further webinars so as everyone is to try and discuss those issues. There's also been numbers of inquiries conducted relating to bank behaviour. I've got here an example, but that's actually my typo. I'll touch on the inquiries in the next slide. There's the Australian Small Business and Family Enterprise Ombudsman. Now this service was set up as a result of the Abbott government inquiry, and it's got a little bit different function. It conducts its own motion inquiries into matters that impact on small business, or the Minister for Small Business can refer matters back to the Ombudsman for inquiry. And I saw on the website that they have actually completed an inquiry into payment times and practices for small business, and generally I think it was concentrating on the way big business treats small business. And I'm fairly confident that that it was found that the Australian big business are one of the worst in the world at paying on time, and some of them are imposing dates like 120 days before they'll pay a small business. Some of the very big, successful, highly profitable multinational companies are the worst at it. So that's the type of inquiry that has made. There is currently an inquiry into advocacy activities relating to the dairy industry, including promoting greater transparency in pricing and visibility of market fluctuations, along with improving dairy supply. And I'm fairly sure Kate Carnell, who's the Ombudsman there, was recently had required all the CEOs of the 4 major banks to come before an inquiry that she was conducting in relation to the way banks conduct themselves with small business. And a lot of that came as a result of the complaints made about the banking behaviour, and that was in relation to, say, the Parliamentary Joint Committee into Corporations and Financial Services inquiry, which is a mouthful, on impairment of customer loans. And that was an inquiry that went right around Australia. Many people appeared before there telling them stories about how the banks had behaved, and a lot of the banks didn't come out all that rosy with that. So, you know, there is a lot of inquiries being made. Government authorities are becoming far more aware of what's actually occurring out there. There's been an inquiry into the expansion of the Financial Ombudsman Service for Australia for the small business jurisdiction. You can go onto the website there, you'll see various submissions made. I know Legal Aid made submissions to ask that it be expanded to accommodate loans up to $10 million and to be able to make compensation up, I think it was $2 million or $5 million, one of the two, I'm not sure, I can't recall. I think it was $2 million. There's reviews in the Code of Banking Practice. Now, I'm sorry, it says here review of Credit Real Finance Act. That's not, that should be not there. It's review of the Farm Debt Mediation Bill. That's, and you can see that we've already referred to that. So please ignore the review of the Credit Real Finance Act, because as far as I'm aware, there's no review on that process. Must acknowledge that the Rural Financial Counselling Services, as Greg had already mentioned, does provide the assistance to the Legal Aid Office in dealing with their matters. And the rest of the slides are how to contact Legal Aid. And now our service here, it's free of charge to Queensland rural producers and to rural-based businesses. No means test apply. The farmer must have for a file to be opened in relation to farm debt matters. The farmer has to be in severe financial crisis, which means if a farmer is being offered mediation, they're obviously entitled to assistance. We do provide general legal advice for primary producers. Part of our role is advocacy role for producers as going to reviews, etc. There's how to contact us and the various legal aid officers.